Now, obviously, this is the unfortunate topic when we have some deals that fall apart. Freddie said, "Yes, I did." We have deals that fall apart, and we start talking about compensation to the seller for their inconvenience. That is our discussion for today. Let me fix this really quickly. All right, so let's get started. So today's topic is obviously escrow disputes, and I want to welcome all of you to Title Tuesdays. Today is Tuesday. I started off and I said, "What day is it?" I mean, it's Tuesday, right? Title Tuesdays. What other day would it be that we will be here having this conversation? I want to welcome every last one of you, those that are coming in to Title Tuesdays. Now, here's the mission of Title Tuesdays, and here's why we said we had to do this. It is to provide a weekly coaching call for realtors. My peoples, as many of you may know, I was a licensed realtor before I was a licensed real estate attorney, and so I always call the realtors my people. And it's a weekly coaching call to discuss the latest trends and need to know information to grow your business. I sit at a fairly unique vantage point in the transaction, and that, as you guys know, as a licensed real estate sales professional, real estate attorney, and a closing agent, I kind of see all these different issues that arise. And so when it's something that I feel like is happening too much, and even if it happens once, if it's significant and I feels like it's going to impact your business, then we right away we get on top of it, and we want to have a conversation about it. Oftentimes, the issues that we see are issues that our our colleagues may feel like, oh, it's just the end of the road. There's no way I can get around this. I'm just done. Here's the release and cancellation. My clients are going to just have a fit. And we talk about it, and I said, well, you know what? There's probably a solution to this. And so let's just have a conversation on what that solution is. And so from that was this comment that I made to someone. I said, you know what? When you encounter an issue that impedes your forward progress, you 99% of the time, specifically in real estate, this is the beauty of the industry that we're in. You have not reached the dead end. You simply reached the extent of your knowledge. You simply don't know the resolution to that issue. And so this is where we come together each week, we mastermind, and we have this conversation surrounding these different issues that sometimes become a impediment to your forward progress. And we say, well, here's the solution. Um, all right. I see your comment, Freddie. We're gonna get to the questions at the end, but I can't help but see it. So at the end of the day, all of this sums up to say what? Learn more to earn more, right? If you learn more where others see impediments, where others see, release and cancellation time, where others see this is not anything that we're going to be able to resolve, someone else sees a solution. They see an opportunity, and they see where a deal can be kept together. So every week we come together, guys. I want you to find a way. It is my goal that you take away a nugget that will allow you to put a deal together, keep a deal together, and get a deal to the closing table. Right? So for those who've not been on the call before and you're like, who is Title Experts? I've never heard of you, but I came across this invitation and I figured I'd jump in. Title Experts, we are an attorney founded and operated title insurance and settlement firm. That's what we do. We believe that we are the epitome of a five-star closing experience. Our mission is to be the most knowledgeable and reliable settlement and title insurance firm in the state of Florida. That is our mission. If you know our tagline, it is knowledge, clarity, superior service. We want to be the most knowledgeable. We want to provide the most clarity surrounding title insurance in the closing process, because most people, they know that they must go to the title agent, but they're not really clear about what we do, how we do it, or why we do it. So we want to provide clarity around that. And then finally, we want to provide a superior customer service experience, right? So there's a lot of title agents that do what we do, but again, we want our experience when you work with us to be a standout experience. For those who we had not had the opportunity to work with, we welcome you to our closing table. If you're under contract or you're negotiating to go under contract, we'd love to work with you. You can send your new contracts to contracts@titleexperts.com. If you have any general questions about our closing process, how to work with us, where we're located, we do close all of Florida. You can send an email to closings@titleexperts.com. And then finally, if you have any questions about anything and you want to speak to someone, just give us a call, 866-5-Experts, and we will answer your call. All right. Now, for those who I have not had the opportunity to meet, hello, happy Tuesday. My name is Ray Cole Jackson. I am the founder of Title Xperts. I am a real estate attorney. You see here a little bit about my educational background. I do have a Bachelor of Arts in Criminology from the University of Florida. Go Gators. You guys know, tell them if there's any no's on the call. What do they do, guys? Tell them to get on their own call, and you can say go no's then. But for now, we're all Gators, right? I obtained my law degree from Santa Clara University in California. I moved back here to Florida and attended the University of Miami School of Law, and I obtained my LLM in real property development. That is a specialization in real estate for attorneys. And finally, I am a licensed Florida sales person. I obtained my first license in California during law school, came back home. I am originally from Florida and obtained my license here. I provide that background simply to say, because I know attorneys sometimes get a bad rep and they're like, oh, they're just gonna kill the deal. Well, listen, title attorneys, we don't get paid until you get paid, right? Unless there's some type of legal issue that we're dealing with. And more importantly, again, being someone that's been on your side of the table in the trenches, I understand again that you don't get paid until it closes. And so we are the ones that we're going to get you to the closing table. And we always say for closing sake, whatever we have to do for closing sake, we'll get that done, right? Now, here's our topic today is these dreaded escrow disputes. These are they can be avoidable, but they arise. And so I want to provide some clarity around what you're facing if you find yourself in the position of an escrow dispute, whether you're representing the buyer or the seller. Now, obviously, escrow disputes generally means that there is a seller that's seeking to retain an escrow deposit, right? So when a real estate transaction fails at the fault or the perceived fault of the buyer, the seller is saying, hey, well, at least we have some escrow that we can go after, right? We want the escrow deposit. Now, you got to understand that there's a clear-cut manner to resolve escrow disputes. And we know that our real estate contract controls the manner to resolve it. Now, what's articulated in the real estate contract, it comes from Florida statute, right? But it is delineated there in paragraph 16, and we are going to discuss it today, what that looks like, right? So the first thing that happens, buyer default, listing agent shoots off a hot email, makes a phone, show me the money. That's it. You're in default. I'm keeping your escrow deposit, right? Or even before what we call a threatened default, right? The lender is a little slow to respond, or that second escrow deposit, we're just not sure that it's made it there yet. There's always that threat comes out immediately. Don't worry, we'll keep the escrow deposit, right? So, but understand, and most of you guys understand this, and if you don't, you'll learn today, that the escrow agent will not disperse the funds without a fully executed release and cancellation until there's an agreement between the buyer and the seller of who the funds should be released to and how much. Is there an appropriation? Is it a split? Then we have a dispute. That is the essence of a dispute. There is no agreement about what's going to happen with this escrow deposit, right? And so what you have to understand is there is a process. The buyer could be 100% clearly at fault, guys. Hate to tell you this. If they do not agree, if they do not sign the release and cancellation, there's still a process. You got to go through the process. And that process we're going to discuss today. So this is why when we get, the phone call, oh, well, release the deposit. We're like, where's the release and cancellation? Oh, the buyer won't sign it. Oh, well, we got a process we need to go through, right? It is not automatic. It's not automatic. And so why do I say that? I can say that to you for the fact that maybe that might be a reason for your seller to hang in there just a little bit, depending upon the circumstances. Give it another day or so, right? Because the escrow, unless the buyer signs the release and cancellation, those escrow funds are not going to be released tomorrow anyway, right? So maybe you want to give it another 24, 48 hours before you pull the trigger and saying, this is it, I'm done. We're not going to go forward with this transaction with this buyer, right? So here's the process. We know that the Florida Realtors, Florida Bar as is contract, or what we call the FAR bar, it is the most commonly used contract. So that's the provision we're going to look at today. I mean, we get 99.9% of the time, that's the contract that comes in for closing. So what does that look like? At paragraph 16, this says dispute resolution. This is how we resolve disputes. It says it right here. So it says, paragraph 16, starting at line 339, it says, unresolved controversies, claims, or other matters in question between buyer and seller arising out of or related to this contract or its breach, enforcement, or interpretation, parentheses, dispute, will be settled as followed. It's telling us how you're going to resolve this. And this is what the buyer and seller have agreed to. Paragraph A, buyer and seller will have 10 days after the date of conflicting demands for the deposit are made to attempt to resolve such dispute. What is conflicting demands? Conflicting demands are buyer sends a release and cancellation. In that line, it says release the 10,000 to buyer, and they send it to the title agent without the seller's signature. And the seller sends a release and cancellation with the $10,000 released to the seller, with it signed by the seller, but no buyer's signature. We got conflicting instructions here. Nobody's agreeing on where these funds should go. That's what you call conflicting demands, right? And so by essence, now we have a dispute. If that is not resolved, buyer and seller shall submit such dispute to mediation under 16B. Again, you don't just jump to litigation. Here's the process. We have conflicting demands. We can't get that resolved in 10 days. Now we go to mediation. So 16B says, buyer and seller shall attempt to settle the disputes in an amicable manner through mediation pursuant to Florida rules of certified and court-appointed mediators. Mediation rules, the mediator will certify their experience, et cetera, et cetera. Disputes not settled pursuant to paragraph 16. If you can't, this is what this is about to say. If you do not resolve this via mediation, it may be resolved starting at line 349 by instituting action in appropriate court having jurisdiction of the matter. That means if you can't resolve it at mediation, now we're going to court. And where it says appropriate jurisdiction, now we're talking about a couple things. We're talking about, well, how much is the escrow dispute? If it's less than about $15,000, now we're in small claims court. If it's above, now we're in circuit civil court, right? We have county, small claims court. We have circuit civil when the amount in controversy, depending upon what that number is, now it's getting serious, right? So we couldn't get it together at the title agent's office. That's a good question, Freddie. We're going to talk about that. We couldn't get it together via email. We couldn't get on one page via mediation. Now we have to go before the court. So Freddie just asked a question about who pays attorney's fees and costs. We're going to talk about that, but that's the next paragraph. See it right there, paragraph 17. Mediation, the parties are going to split the fee. Their attorney's fees for mediation, they're paying their own costs. If you bring an attorney to mediation, you're going to pay your own attorney's fees. Guess what? If you don't resolve this at mediation, again, going down to line 354, we're going to talk about this a little bit later on, but since Freddie asked the question and we're here on the slide anyway, guess what? The prevailing party right here shall be entitled to recover from the non-prevailing party costs and fees, including reasonable attorney's fees incurred in conducting litigation. That means you better be right. If you take this to court, you better be right, because the party that the non-prevailing party, meaning the loser, will be paying the winner's attorney's fees and costs. Your clients have to understand this. I would assume 9 times out of 10, they're going to be advised of this if it makes it to this point anyway, right? I would assume they're going to seek legal counsel before they go to mediation and not agree to something. They have to understand that this is an escalating issue as it relates to the cost exposure for the parties, right? So that's the paragraph. Now, how we get to the final resolution is different based on the type of escrow agent that's holding the escrow funds, right? So, who is the escrow agent? That's the first thing we look at. If the escrow agent is a real estate broker, so this here is blank. So, name, whoever, Caldwell, Keller Williams, Elite, uh, motivated connection realty, whomever, United, you name it. If the broker is holding the escrow, process is a little bit different. The real estate broker is going to have to follow FREC's rules. They're going to get involved. They're going to ask FREC, which is our Florida Real Estate Commission, and they're going to have them to assist them in this resolution, and it's pursuant to Florida Statute 475. You obviously don't have to have this memorized, but certainly if you've just taken the real estate course, you know who FREC is, and you know Florida Statute Chapter 475. That's our main statute as it relates to real estate licensing and process here in Florida, right? And so the licensed real estate broker is going to get FREC involved, because here's what the statute specifically says. When the Florida real estate license broker entertains doubt as to who's entitled to the escrow deposit. So again, United Realty is holding the escrow deposit. Buyer and seller sends their release and cancellation, not fully executed, right? The seller sends theirs saying that the funds should be released to them. The buyer sends theirs that the funds should be released to them. The real estate broker now has doubt about who's entitled to the escrow deposit. They should. Here's one thing you guys have to completely understand. Regardless of who's holding escrow, the title agent, if it's a title company, if it's an attorney, if it's a real estate broker, I'll say should not, because stranger things have happened. They should not make the determination of who is right. And Freddie's asking all the questions. How do I know? You don't know. You're not the one making that decision. And we're going to talk about that into further slides. Listen, if your title agent, your real estate attorney, or your real estate broker has made a decision on who's entitled to the escrow funds without having a fully executed release and cancellation signed by both parties, you better run. That's a problem, right? So the real estate broker, they're going to promptly notify FREC. FREC, remember, it's the Florida Real Estate Commission. They're going to notify FREC of the conflicting demands. So they're first going to let FREC know. And then they're going to proceed with one of the following options. They're either going to request that FREC issue an escrow disbursement order, what we also call an EDO, determining who's entitled to the escrow property, the escrow funds. FREC, you tell me who should get this. Secondly, they may, with the consent of all the parties, submit the matter to arbitration. You guys remember, there is a rider that the parties can agree to go to arbitration instead of litigation in the event of a dispute. The base contract says that you're going to mediation. You can attach a rider to say, it says you're going to mediation and then litigation. You can attach a rider to say, we're not going to litigation. We're going to go to arbitration in the event that we cannot resolve this dispute via mediation. What is the difference between arbitration and litigation? Arbitration, you're not bringing a jury. You're going to have one individual who's going to hear the facts and make a binding decision. This is different from mediation, wherein one individual will hear the facts and they will apply the law and say, well, if you were to take this to litigation, here is the likely outcome. Got the difference there? Here's your likely outcome in mediation versus arbitration. the decision maker says, this is your outcome. The difference between arbitration and litigation is cost and time involved. Arbitration is a little bit more succinct. You're not picking a jury, all the costs is such associated with it. And so the parties can agree to arbitration. The third option is by interpleader or otherwise seek adjudication of the matter by the court. The real estate broker can say, listen, I'm just going to place these monies with the court. Interpleader means I'm going to bring you guys into this action. You guys come on here, come on buyer, come on seller. Here you guys go. You guys go talk to the court, talk to the judge, and let the judge determine which of you is entitled to the escrow funds. Or their fourth option is with written consent of all parties, they can submit the matter to mediation. They can submit it on their own and say, hey, this needs to go to mediation. Here are the facts. Here are the parties. We need this resolved, right? That's the real estate broker's process. They're going to get FREC involved. Let somebody in. They're going to get FREC involved to make these determinations and follow their process, right? Now, let's talk about when you have an escrow agent that's an attorney or a title company. Remember, that's different from a licensed real estate broker. And here you see Title Experts, right? That's our firm, our contact information. An attorney or a title agent, they're going to treat the dispute as a civil legal matter from the get-go. They're going to say, this is a legal dispute. You guys need to deal with this in the court of law, right? They're going to immediately take this thing out of their office, immediately. Some wait. Pursuant to the contract, the buyer and the seller have 10 days. The escrow agent can allow the funds to remain in their account, quote unquote, indefinitely. They're generally not going to do that. They will give you some time. Like they can, it can be years that it's in there. It's up to them. If they want to force you guys to clear their escrow account and go resolve the matter somewhere else. However, when they remove those funds are immediately going to the court for the court to initiate an interpleader action. Remember what did we say that was? That is, the title agent or attorney is going to file a lawsuit and they're going to name the buyer, the seller, make them party to this suit, and have the court resolve who is entitled to those funds. Now, here's what's important there. The cost and fees associated with filing this action is deducted from the escrow funds, right? So this is something else to consider when the parties are not agreeing to who should get the funds. You say, hey, well, you guys only have like $3,000 in here. You do know if the title agent files an interpleader action, they're going to deduct their attorney's fees and the cost to file a legal action. Now we're looking at, $2,000? Is it worth it? Can we just get a resolve here, right? They're going to absolutely deduct their funds, right? The buyer and seller proceed to mediation pursuant to the contract. If it's not resolved at mediation, again, the buyer and seller proceed to litigation or arbitration, the same thing. So the difference is the title agent, attorney, they're not involving FREC. They are going to, for all intents and purposes, take it to the courts, file an interpleader action, and the buyer and the seller will have to take their attorneys, they will have to hire attorneys and resolve the matter. Freddie's question, what happens if the broker is unfortunately lazy and won't take the step? They're required. That's the thing. And this is why a lot of real estate brokers do not, besides the escrow maintenance and reconciliation and auditing and those types of things, this is the reason why a lot of brokers will not hold escrow. They don't want to be involved in this process. They have enough they're dealing with. They don't want to be involved in that. So to answer your question, Freddie, if they want to be in compliance with FREC, they must take these steps, right? Now, what are some common contract defaults that we see that create these issues? Failure to make a second escrow deposit. That's a breach all day long, right? failure to make, and so failure to make the first escrow deposit technically is a breach. And the question that I get, but if you think through this, it's really not worth having the conversation, is, oh well, they didn't make their first escrow deposit, can we force them to make the deposits for the seller to retain it? Like, really? How are you going to force them? It would take legal action to force them to make to find them. I mean, come on, you're going to spend money to, unless it's a significant amount, potentially, but just think about the fact that you're going to spend money to force your buyer to be found a judgment against them that they should have made the escrow deposit for you to hold, et cetera, et cetera, et cetera. So again, unless it's a significant amount, that's probably a non-starter and it's not worth having that conversation. The second is a failure to cancel the contract during the inspection period. And obviously this is going to fall into if this is a cash transaction, right? If this is generally your inspection period is a contingency, and then what's your next contingency, guys? The financing, right? And so if they didn't cancel it based on the inspection period, they could potentially cancel it based on financing. If it's true, right? There's some provisions in there that don't allow you to play funny business with that. But assuming that they're not able to get financing, then they'll cancel it for that contingency. But assuming it's a cash transaction, buyer failed to cancel, let's use is an investor. Investor buyer fails to cancel the contract during the inspection period. Guess what? You have no basis to release of your escrow deposit, potentially, if that's the only thing that we're dealing with, right? Failure to make loan application or obtain loan approval. This is the big one, right? This is the big one. Failure to make loan approval. You do know you also have to make the application. There's a deadline there for that. Failure to do that is a breach. Generally, we don't have an issue with that. We do have the issue with the failure to obtain loan approval. Now we're getting into going back to, a couple prior classes that we've had, closed and funded. We talked about the anatomy of a transaction, talking about making sure not to miss that loan approval period, going back to the contracts class, talking about how important it is not to miss that loan approval deadline. If you miss it, that's basic, guys. Don't miss that. What happens if a buyer is not complying with the lender in order to get financing approved? That is a breach. That is in the contract. That's a good question, Freddie. That is absolutely in the contract, that the buyer must comply with the lender's requirements to be approved for a loan. It says it right there in the contract. And if the buyer defaulted on the first escrow and the second escrow, I'm not clear on the second question, Freddie, but failure to make an escrow deposit is a breach. Again, generally, you're only talking about retaining escrow funds on the second because the first has been made. Remember, we're not really trying to, we're having a conversation about forcing a buyer to make an escrow deposit that they haven't made for you to retain it. Move along, guys. Again, unless it's 50 grand, now we're having a different conversation, right? So attorney's fees and costs. We talked about this earlier. We'll just reiterate here. As it relates to mediation, if you have to go to mediation, the parties will equally split the mediation fee incurred in any mediation permitted by this contract. Generally, mediators are going to ask for about 2 to 3 hours. And mediators can cost from, anywhere from $350 to $500 per hour. And these are funds that have to be paid out in advance of the mediation, in addition to your attorney's fees. So you guys do the math. The attorney is going to charge the same amount. They're going to charge for a couple hours because they have to prepare and then they have to attend. So you're looking at easily about $1,500 just to get started on an escrow dispute, easily, right? On both sides. So these are things to take into consideration, right? If your client is digging their heels in about an escrow dispute. Now, you see, you pay your own costs and expenses, including attorney's fees, incurred in conducting a mediation. And then finally, again, to reiterate, in any litigation permitted by this contract, the prevailing party, whoever wins, If you go to court, you will be entitled to recover from the loser, the non-prevailing party, costs and fees, including reasonable attorney's fees incurred in conducting the litigation. Now, let me hit this here, reasonable attorney's fees. The reason why that's there is because you can't go and win and say your attorney costs $1,500 per hour. That's not reasonable, right? The court is not going to go for that. Reasonable attorney's fees, $350 an hour, $450 an hour, $500 an hour, maybe even, but not $1,500 per hour, right? But that's still a pretty big number, right? So you want to be sure that you're right when you go to court, because you will be entitled to attorney's fees. One quick point I want to make there, because I think I've had this question before, and hell, we're here. You guys might as well get the answer to it. Understand that a party is not entitled to attorney's fees unless it's provided for in statute or in agreement, right? So this is not just here in real estate. If you start talking about attorney's fees, guys, know that no one is entitled to attorney's fees unless the statute says a party is entitled to attorney's fees, or you have an agreement, a written agreement between you two that you will pay attorney's fees. Last point I want to make for that in clarity: every dispute does not entitle a party to attorney's fees. Not every dispute. So you can go to court and lose, or you can go to court and win rather, but you still won't be entitled to attorney's fees unless there's a statute that says you get attorney's fees in that cause of action, or you guys have an agreement that says in the event that we have a dispute as it relates to this particular agreement and we have to go to court, if I win, I'm entitled to attorney's fees. If you win, you're entitled to attorney's fees. All right. So I'm gonna move off that point. Again, that's why it's in the contract. Attorney's fees only if it's statute or in an agreement. You don't just get attorney's fees because you won. And it doesn't happen that way. Another important point is to note that in an escrow dispute, in and of itself, does not prevent the seller from advertising or selling the property. I get that question. Now you have an escrow dispute. Can the seller not sell? Seller can. If it's only an escrow dispute, seller can go back on the market. Done. Now, if it's the reason why it says in and of itself, if there's some other issue that's in dispute, the buyer can file an action and tie the property up. But if it's just the seller is saying I'm entitled to escrow on this particular transaction due to the buyer's default, they don't have to wait until that's resolved before placing the property back on the market for sale. And I'm sure that's going to set a lot of you listing agents free. You're like happy, like, ooh, that's all I came for. See you later, Ray Cole. Richard, up to what point should the buyer wait for the loan approval before canceling? What is the official reason for canceling before the actual deadline? Up to what point? The debt, you should wait, give it the date, your deadline for loan approval. 11:59, if it's only based on the contract, right? If we're talking about that rollover, now you're looking at 4:59, 5 p.m. right? If you're rolling forward on the deadline, then it's for 4:59. Just know what your time is for your deadline, and what is the official reason for canceling before the actual deadline? You didn't get approval. You've done your due diligence. You've submitted all your documentation. No loan approval. I got to cancel. Now, should you cancel right away? You probably should have a conversation about an extension of the loan approval. If it's something that, the lender just needs a little bit more time for the underwriting, or maybe the appraisal wasn't done right away. There is a backlog in getting appraisers out. Have a conversation. Don't just cancel. Have a conversation about extending the loan approval deadline. One thing you absolutely do not do is allow the loan approval deadline to lapse. Don't miss that. And then wake up the next day still mulling around in your head how you're going to resolve it. Absolutely not. Like, let's deal with this before you miss the deadline, right? How do you confirm a loan approval from the lender? Lender says, here's your loan approval. Here's your loan approval. They're approved. The only thing we need is, final verification of income. If they were saying if it's a buyer that's also selling a property, the only thing we're waiting for is confirmation that they're, vacation home sold, those types of things. Remember, we talked about before, you don't want to receive a loan approval with conditions that look like when you first started. Like, now what is this? Like, I need a very clean loan approval with just a couple of few requirements or conditions that you would expect in any transaction. And I see Renee is on here. Renee is a lender as well. So if you want to chime in the chat, you're more than welcome. Any questions on this? Again, whole point of is us to come in here, get this. You guys need to know, number one, just because you have an escrow dispute and you determine, your seller says, I want to retain the funds, it doesn't happen like that. It is not 1, 2, you get the check issued tomorrow. There has to be a release and cancellation executed by both parties agreeing to release the funds to the seller. Unless you have that, you have to go through a process. Finally, you guys want to be sure that you not try to give legal advice. Don't try to give legal advice. It is not worth you. First of all, that is a 3rd-degree felony. And the only thing you need to do is tell your client what the process is. Don't try and tell them what the probable outcome is, because when you start telling them what the probable outcome is, now you're giving legal advice, right? If you start telling the seller, well, we know for sure, it is absolutely clear that their loan approval deadline was today, Tuesday, July 13th. No, their loan approval deadline was Tuesday, July 12th. Today is July 13th. We don't see a loan approval. There is no way in the world that they're going to be able to get this. Don't say that. You don't know. But don't start saying the statute says, unfortunately, the buyer did not obtain their loan approval pursuant to the contract. For all intents and purposes, that loan approval should have been received by yesterday, July 12th. As of today, July 13th, they do not have their loan approval. As a matter of fact, I'm not hearing from the buyer's agent. I'm not hearing from the lender. We're obviously going to send over a release and cancellation for the funds released to you. We hope that they sign it without contesting it. If not, then there is the contract. You point them right back to the contract. The contract has a dispute resolution process that we will follow. Period. Obviously, if you need an attorney, we'll help you. Oh, Tamika, I'm glad you found value in that. Now, Tuesday's closing thought. And this is important because Mondays are rough sometimes. Tuesday, you should have a little bit of, you should have your legs up under you. And so this is something that I came across. And if you guys follow me on social, I send out a quick message. And so I wanted to share my Title Tuesday guide, a closing thought. You like that? Cute. Closing thought. Yesterday, you said tomorrow. Just do it. Yesterday, you said tomorrow. All right. There's a lot of goals. There's a lot of aspirations. There's a lot of tasks on your list. And yesterday, you saw it and you said tomorrow. Tomorrow, 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 tomorrow. Whatever that thing was you said tomorrow to, just do it. Just do it. I promise you, you'll be closer to where you need to be today if you just do it today. Start small, start scared, start unsure, start frustrated, start tired, start aggravated. Whatever you have to do, just start and just do it today. All right? Listen, we did it. We did it. We did it. We did it. Escrow disputes, you guys should be good with that. If you have any questions, you know where to find me. I'll see you guys next week.